Deals dying at title. How to keep abstract and title issues from blowing up your closings. Ever had this happen? You're a week from closing on a solid Iowa listing. Everyone's packed, utilities are scheduled, the moving truck is booked, and then you get the email. We have a problem with the abstract and title. We may need to delay, or we might not be able to close at all. Now you're making the worst phone call in real estate. Hey, so we might not be closing next week after all. If title and abstract issues have ever blindsided one of your deals, this video is for you. I'm a real estate attorney, and I'm going to show you how to keep Iowa abstract and title problems from blowing up your closings, and how to plug a law firm into your process so you're not fighting these fires alone. I'm Jeremy Danilson, real estate attorney and founder of Danilson Law PLC here in Johnston, Iowa. Our firm runs attorney-led security-first closings and provides seller-side transaction support for Iowa agents who are tired of deals dying at title because the abstract wasn't handled properly. The title opinion came in late, or a small issue turned into a big last-minute mess. This video is for Iowa listing agents who want fewer last-minute surprises, more control over the title process, and a legal team to back them up when abstract and title issues pop up. This is general information, not legal advice to any specific deal, but it is based on what I see in Iowa transactions every single week. Here's what we'll cover. Why Iowa's abstract system makes title more hands-on than a lot of agents realize. The most common title issues that delay or kill closings, what a proactive title and abstract game plan looks like, and how an attorney-led closing team like Danilson Law changes your risk profile, and how to implement a simple plug-and-play title checklist on every listing. Let's start with the part that makes Iowa, well, Iowa. Part 1, Iowa's abstract system. Why title here is different. In a lot of states, agents are used to hearing, title insurance will take care of it. But Iowa's different. We're an abstract state, which means each property has an abstract of title, a physical or digital document that shows the history of the property, deeds, mortgages, liens, judgments, easements, and so much more. An attorney then issues a title opinion based on that abstract to say whether title is marketable and what needs to be fixed before closing can happen. In practice, that means there are 3 moving parts you need to care about: updating the abstract, reviewing the abstract with a title opinion, curative work, fixing issues so you can deliver marketable title. When those pieces aren't moving early, or when nobody's clearly in charge, you get panicked emails a week before closing. Like, we can't fund until this is resolved, calls from the lender. And sometimes, deals that just simply die. As the listing agent, you're left looking like the one who didn't see it coming, even though title is technically someone else's job. The truth is, you don't have to be the one fixing title issues, but you do need a system and a team that gets them handled early. Part 2, the most common title problems that blow up closings. Let's talk about the usual suspects. Here are the issues I see most often when I'm reviewing abstracts. Old, unreleased mortgages. The loan was paid off years ago. The release was never properly filed or recorded. Title still shows a mortgage that exists. Result, everyone scrambles to track down payoff records or get a release from that prior mortgage holder. Judgments and liens. Old medical bills, credit cards, or other judgments that did attach to the property. Unpaid taxes, city special assessments, mechanics liens from past work. Sometimes the seller doesn't even remember them or assume they were gone. Estate and probate issues. The property passed through an estate, but the probate may not have been handled completely. Maybe not all heirs signed what they needed to sign. Or someone still has a legal interest in the property they didn't know about. Divorce and ownership complications. One party was awarded the house in a divorce, but title was never updated or a deed was never delivered. A former spouse or co-owner still shows up in the chain of title. Possibly boundary and easement problems. Old surveys that don't line up with the reality. Easements that weren't disclosed or weren't understood. Driveway access issues that make lenders very nervous. Any one of this long list I just went through can cause delays, extra paperwork, or worst case, a bombed closing. What's the common theme? The later we find them, the more painful they are. When these show up 3 days before closing, everybody suffers. Your client, the buyer, the lender, and your reputation. So let's talk about what it looks like to get in front of these instead. Part 3, a proactive title and abstract game plan you can use every time. Here's the mental shift. Stop thinking title will handle it. Start thinking, what's my process for making sure title and abstract are moving with enough runway? Here's a simple plug and play title plan you can use on your listings. Step 1, start the title conversation early. The moment your seller signs the listing agreement, ask, where is your abstract? Do you know when it was last updated? Has there been any divorce, estate, or major ownership change since you bought the property? You don't need to solve anything, you're just gathering early warning signs. If you're working with our team at Danilson Law, this is a great moment to say, I partner with a real estate law firm that can help us get in front of any title or abstract issues before we're under a tight deadline. Let's get them involved early. Step 2, know who is updating the abstract. On every listing, your checklist should include who is responsible for updating the abstract. Has the abstract update been ordered? If the seller is responsible, which is common, our office can coordinate with the abstractor, push that process forward, and keep you posted on timing. The earlier the abstract is updated, the more time we have to review and fix things. Step 3, get the title opinion ordered ASAP after offer acceptance. Once you're under contract, the next critical question is, who is issuing the title opinion and when will it be ready? When we're your buyer's attorney, that's us. Our process is get the updated abstract, review it thoroughly, issue a title opinion, then clearly explain any problems and the curative path forward. You get to say to your buyer, the law firm has reviewed your title and will let us know what, if anything, needs to be done so your closing stays on track. Step 4, attack curative work with time to spare. If there are issues, you want them discovered with weeks, not days, to go before closing. That gives us time to track down payoff records, request releases, draft and record corrective deeds or affidavits, coordinate with lenders, prior attorneys, or other parties. Your role no longer is frantic middleman, it's calm professional, because you know someone capable is handling the fix. Part 4, how an attorney-led closing team changes your risk profile. Let's talk about why this matters for you as the agent, not just for the deal. When closings blow up at title, sellers rarely say, well, technically this is a title abstract issue. They say, my deal fell apart. My agent didn't catch it. This was a nightmare. Even if you didn't cause the problem, you're still the face of the transaction, the one whose name they remember, the one who either gets blamed or praised for having a solution. When you bring in an attorney-led team like Danilson Law, a few important things change. You're no longer the only one watching the legal landmines. We're reading the abstract and the title opinion. We're spotting curative needs. We're driving the fix. You gain a clear, defensible process. When I take a listing, I bring in a real estate law firm to review title and abstract as early as possible. That's a strong narrative if anyone ever asks, what did you do to protect your client? You reduce last-minute panic. Problems are identified sooner. Solutions are executed with less chaos. You make fewer we might not close calls. You look more professional in the eyes of high-end, remote, or sophisticated sellers. They're used to seeing teams, not solo operators. My agent works with a law firm that handles the legal and title side is exactly what they want to hear. And remember, our closings aren't just legally focused. They're security first. That brings us to one more layer of protection. Part 5, from clear title to safe money. Security first and closing lock. Even when title is perfect, there's another risk at the end of the deal. Getting paid safely. You've probably heard about wire fraud, hackers watching email chains, fake wire instructions. Proceeds or down payments wired to criminals instead of closers. If you help fix title issues, only to have your seller's money stolen on closing day, no one is going to feel good about that transaction. At Danilson Law, we treat both title integrity, you actually own what you're selling. Money security, your funds go where they're supposed to, as part of the same security first model. That's why we use a secure system, Closing Lock, to share and confirm wire instructions, keep sensitive account and routing numbers out of normal email, give your clients a visible, concrete process for sending and receiving funds safely. So when you work with us, your story is we get your title clean and we protect your money when it moves. That's the combination today's sellers want. Part 6, how to talk about this with your sellers without sounding like a lawyer. You don't need to lecture your sellers on abstract law. I can do that. Here's a simple language you can steal for your listing appointments. In Iowa, your property has an abstract, a record of everything that's happened with the title over the years. If there's a problem in that history and nobody catches it until the week before closing, your whole deal can be delayed or even fall apart. That's why when you list with me, I bring in an Iowa real estate law firm, Danilson Law, to help get your abstract updated, review your title early, fix issues before they become emergencies, and then run a secure attorney-led closing so your money actually reaches your account safely. You're not promising perfection. You're promising a process and a team. If they ask, do I really need a law firm involved? You can say you're selling one of your largest assets. You can have just me or me plus a real estate attorney watching your title, explaining your documents, and protecting your funds with a secure system. I think you deserve the team approach. Part 7, putting this into practice on your next listing. Let's turn this into action. Step 1, pick a listing that cannot afford a title surprise. Think maybe your higher priced listings, estate or divorce situations, older properties with long ownership histories, remote sellers, or more sophisticated clients. That's your test case. Step 2 is to loop Danilson Law in before you're under the gun, before you go live, or as soon as you accept an offer, reach out and say, I've got a listing where I really want title and abstract handled proactively. Can we plug this into your seller transaction support and security first closing process? We'll talk through the property history, identify likely title and abstract pressure points, coordinate the abstract update and title opinion, and build a plan for closing that keeps you out of last-minute chaos. Step 3, make our involvement part of your standard process. Once you see the difference on that one listing, you can confidently say, on every listing, my process includes a real estate law firm that reviews and helps clean up title early, handles the legal closing work, and protects your funds at closing through a secure, modern system. That becomes part of your brand as an agent. Stop letting title surprises define your deals. Deals don't have to die at title. If you start the abstract conversation early, get the title opinion ordered with enough runway, and have an attorney-led team ready to jump on curative work, and run a security-first closing that protects your client's money. You're not just hoping title works out anymore, you're managing it. If you're an Iowa listing agent and you're done with last-minute abstract surprises, panicked calls because title isn't clear, and closings that feel more like near-death experiences than professional transactions, use the Book a Discovery Call link on the Danilson Law website or the link below this video, and let's talk about making Danilson Law your default attorney-led security-first closing partner. On that call, we'll look at your current process from offer to close, identify where abstract and title issues have been burning you in the past, and we'll map out how to plug your next listing into our proactive title, abstract, and security-first closing system. I'm Jeremy Danilson with Danilson Law. Let's stop letting title surprises control your closings and start using a legal and security team that keeps your deals alive.